I'm Hearing Officer Dr. Linda Valentini. In the session that follows, I will provide information about special education due process, covering a wide range of topics. I've been a hearing officer for about 20 years, and in those 20 years I've presided over several thousand cases and have held hearings on several hundred of those cases. I am a clinical psychologist by training, and I also hold school psychologist certification in the Commonwealth of Pennsylvania. I worked in the mental health field for years before starting my work as a hearing officer, which I do love. I want to talk about you as parents and how important it is for you to be informed parents, because your children are your primary interest, and their education certainly is high on the list of the things that you want to do well for them. Throughout this talk, I will be referencing school districts, charter schools, and intermediate units as an LEA, which stands for Local Education Agency. The important thing to remember is that your child's education is a partnership between yourself and your child's LEA. And while the school staff are the education experts, you are the parents, so you have to make sure that you understand what's going on. If you don't understand something, ask questions. Don't ever sit there quietly if you don't understand something. Some parents don't want to say, "Hey, I don't remember what this is. Please explain it again," but it's perfectly okay. It's better to get things straight in your mind when you're working with your child's school so that you can be the very best advocate for your child. Your child's IEP is a legal contract for your child's education, so you need to be able to read it and to understand it. One thing that both you and school staff should always be sure of is that the IEP and related services in it are being implemented. It is very important that you and your LEA know that your child is getting the services that are in that educational contract that you and your LEA have created. Bring concerns to the school's attention. Or if you're worried that some things that are supposed to be going on are not going on, please be sure that at the earliest possible date, you bring that to the attention of the school staff. They want to be able to do a good job for you, and sometimes if you don't tell them what your concerns are, they won't know until things get heated up to the point where your energy goes into being angry. Be reasonable. Don't be the unreasonable parent who emails 4 times a day and then expects a response by 7 a.m. the next morning. But certainly do email when you have concerns or speak directly to school staff whenever you can. When you have a conversation with someone from the school, document that with a follow-up email so that everybody's on the same page. You can say, for example, "We discussed X, Y, and Z. My understanding is this. Tell me if this is your understanding as well." This way you have documented that the parties are on the same page. When concerns arise, first ask for an informal meeting. Hopefully at that meeting your concerns and questions can be addressed to everyone's satisfaction and the child's benefit. It's always a good idea to take notes of the meeting to help you remember important points. As I said before, follow up with a verification email. If after an informal meeting you still have concerns, then ask the IEP team to convene. An IEP meeting is a formal meeting where you and the school staff can discuss concerns that you both may have, and where the team can make revisions to your child's educational contract. At times, although the team may ordinarily be friendly and working together for the child's best interest, you and the LEA may feel that an upcoming IEP meeting will be difficult and may get pretty tense. If you and/or the LEA anticipate that this will be the case, there is help. The Office for Dispute Resolution in Harrisburg, ODR, offers what's called IEP meeting facilitation. That is, ODR would send someone to your location to sit in on your IEP meeting and help the IEP team communicate as well as possible. The IEP facilitator will not write the IEP or take sides, but will help the parties with the IEP meeting process. One thing that you as parents have to understand that is a difficult thing for parents to understand is that what the law guarantees your child is an appropriate education. Appropriate does not mean ideal. Appropriate does not mean the best in all possible worlds. Sometimes appropriate doesn't even mean better than something else. Appropriate asks if your child's goals and interventions address your child's needs in a way that is designed to provide meaningful educational benefit in light of your child's circumstances. If you believe that after an informal meeting and an IEP meeting, and then possibly a facilitated IEP meeting, that things are still not going well, then you might be considering asking for mediation or a due process hearing. There is information about mediation on ODR's website. Today, I'm going to focus on what I know, and that is due process. If you believe you need a due process hearing, ask for it. And a hearing officer who is an outside person, an objective person, an unbiased person will give you and the LEA a decision about the issue or issues that you're having a dispute about. But keep in mind that as important as a procedural safeguard due process is for parents, it is always best to resolve issues with the LEA without having to litigate. Litigation is difficult for everyone. A good way to prepare for a hearing is to go on the website of the Office for Dispute Resolution and look at some hearing officer decisions. All the decisions the hearing officers have rendered over the past many years are on the web. They are searchable by the name of the hearing officer, by the school district or the intermediate unit, and by the issue that the hearing addressed. If the hearing addressed more than one issue, the decision will pop up in more than one place. It's a good idea to get a sense of how hearing officers have decided issues similar to your issues by reading the decisions that are out there. Parents who are going to due process certainly also should look at the Individuals with Disabilities Education Act, the IDEA, which is the federal law, and at Pennsylvania Chapter 14, which is the Commonwealth of Pennsylvania law. I do caution you that it is one thing to read something, but it's important to really know what you are reading means. A good example of that is that my Aunt Sis had a great recipe for carrot cake that she passed on to me. It was fabulous, and I made it a lot and everyone enjoyed it. One time I made the cake for friends, and they were telling me how good the cake was, and I said, yeah, but it's a pain in the neck to make. My friend asked me why, and I said, well, it's messy. The recipe says to mix it by hand, and the stuff gets under all my fingernails and my rings, and it's really a pain. After she picked herself up from rolling on the floor laughing, my friend said, Linda, mix by hand means use a spoon. So what I've learned is that you have to understand what something means as well as what it says. Okay, now if you decide you need a hearing, your next major decision is whether you're going to have an attorney or not. LEAs are required to have an attorney for all due process hearings, but parents have a choice about having an attorney. If you do want an attorney, get one early in the process, and be sure to get one who specializes in special education. There are advantages to having a special education attorney. The advantages to having attorneys, and I'm not an attorney, so I'm not drumming up business for colleagues. The advantages to having an attorney are that they have a great deal of experience, they understand the meaning of the federal laws and the state laws, and they have relationships with LEA attorneys with whom they've worked together in the past to resolve cases as well as to go to hearings. Your attorney will be vigorous in presenting your case, but your attorney will also first try to amicably and fairly settle the case rather than having you have to go to a hearing. By the way, in Pennsylvania, well over half of hearing requests filed never get to an actual hearing. The hearing requests that are filed settle. That very high settlement rate is in part due to the good working relationship of the special education attorneys on both sides, as well as to the resolution meeting that parents and their schools must have, which I will touch on later. One important note about having an attorney, if you're sitting there thinking, who can afford an attorney, is that if you win your case, your attorney will get all or a portion of his or her fees from the LEA. Many attorneys offer a free consultation to see whether your case is something that they're willing to take to due process. They will also give you an idea about the chances of your being able to prevail. I guess the most gain in having an attorney is less emotional wear and tear on the parents because, believe me, sitting in a hearing is difficult, and the distress and the anxiety that both sides, parents as well as school staff, experience can be intense. Hearings are not a piece of cake. They're not fun for anybody, including the hearing officer. Hearings are litigation, and litigation is fighting. If you have an attorney do that for you, it certainly will make it easier for you. However, you can represent yourself in the due process hearing, but carefully consider the issue of attorney representation and make the decision that makes sense to you. Parents who represent themselves can win in a due process hearing. The other hearing officers and I have had cases over the years with parents who represented themselves and have prevailed. In order to have a hearing, you or your attorney must file what is called a complaint or request for due process. You can find the form on the ODR website. Please be sure that if you're filing the complaint yourself, you answer all the questions that are on the form. There are certain routine questions that have to do with the name and address of the child and the parents, the child's birth date, the child's disability, and the school the child is attending. In the next very important sections, you have to explain exactly what is the issue or what are the issues about which you want to have a hearing, and some factual information about those issues, as well as what resolution you're seeking. Make sure that you have the whole form filled out. You or your attorney will send the complaint form to the Office for Dispute Resolution, and also at the same time, there must be a copy sent to the LEA against whom you're filing the complaint. The day that ODR and the LEA receive it is day 1. Within the first 15 calendar days, the LEA must convene a resolution meeting. By law, parents, you must go to the resolution meeting and you must participate unless both parties decide to waive the resolution meeting and inform the hearing officer of this in writing. I firmly discourage parents and LEAs from waiving the resolution meeting because it is a valuable tool towards helping the parties get back on the same page. Sometimes parents say, I've been talking to the school district all these many weeks. I've been fighting with the school district at IEP meetings and things haven't changed. Nevertheless, I advise you strongly that you need to go to the resolution meeting because 1, the law requires it, and 2, once you've filed for a hearing, you and the LEA are on a different footing, and there's more incentive to work together to resolve the issue. Sometimes the resolution meeting is the place where the problems that the parents are concerned about are resolved. If in fact parents decide not to come to a resolution meeting, it is the right of the LEA to ask the hearing officer to dismiss the complaint. After the 15-day period in which there must be a resolution meeting, there is an additional 15 days for the parties to try to work things out. Meanwhile, very shortly after you file for the hearing, usually that same day, a hearing officer will be assigned and will set a hearing date anywhere from day 31 after the filing date to about day 45 or 50, unless the parties have waived the resolution meeting, in which case the hearing date must be earlier. The decision due date, or DDD, is the 75th day starting with day 1, the day the complaint was filed, unless the resolution meeting has been waived. If absolutely necessary, either side can ask for some additional time to prepare for the hearing, or can ask for a postponement, also called a continuance, for reasons such as prepaid vacation, a pre-planned medical procedure, a school holiday, or the like. If you need a date change, you must email the hearing officer, copy the attorney for the LEA, and explain exactly why you need a date change. However, you must keep the decision due date in mind when you ask for a postponement. Extension of DDDs can be granted by the hearing officer at the request of either party, only for good cause. If you have an attorney, all correspondence from the hearing officer and from the attorney for the LEA will go through your attorney. Nothing will go directly to you. If you don't have an attorney, in other words, if you are pro se, meaning representing yourself, the hearing officer will send correspondence directly to you and to the attorney for the LEA. If you are pro se, in addition to getting correspondence from the hearing officer, you will also get correspondence from the attorney for the LEA. You can also expect direct correspondence from the LEA staff representative about scheduling the resolution meeting. The hearing officer's correspondence is very, very important. Read it carefully. Email is the default method of correspondence. The hearing officer will provide clear directions about how to prepare any documents that you want to present to support your case and what the hearing officer's expectations are in terms of procedures. If you need to contact the hearing officer for any reason, please be sure to copy the attorney for the LEA on your email correspondence. No email should go directly from parents to the hearing officer or from the attorney for the LEA to the hearing officer without the other party being copied. However, while you or your attorney cannot communicate with the hearing officer without copying the LEA's attorney, you or your attorney and the LEA's attorney can and should communicate with one another without involving the hearing officer. Hearing officers can give parents who are representing themselves some information on procedural matters, requesting subpoenas, for example, or marking documents. But the hearing officers cannot communicate with you or with the LEA or its attorney about the merits of the parties' positions in the case. ODR is now offering a new service that provides a person who will talk over the phone to a parent who is representing him or herself in due process and walk them through the procedural steps they need to take in order to take part appropriately in the hearing. Again, this person cannot give you any advice about your case in particular and certainly can't give you legal advice, but can answer all the technical questions that pop up in terms of procedures and what will happen at the hearing and how the hearing will go and other important things that you as a parent need to know. One of the things that needs doing as a pro se parent is getting documents together. In fact, even if you have an attorney, the attorney will ask you to give him or her any papers related to your child's education. Any report cards, any IEPs, copies of your emails to and from the LEA, etc. These documents may be used as exhibits to support your case at the hearing. I always tell attorneys as well as pro se parents to please limit the number of witnesses that you're going to call to testify. My colleagues and I don't want to hear the same thing from 6 different people. If someone testifies credibly to a particular fact, then that's all you need. We don't want repetitive testimony or testimony that is not relevant to the case. For example, if you have an issue with the IEP for this school year or last school year, we don't want to hear about an IEP from 3 years ago or about your child's history with the LEA from the beginning. The hearing is not a place to air your grievances that have accumulated since the start of your child's education. The hearing is a place to get a specific issue or situation resolved with a person who is an independent, unbiased person with a great deal of experience in special education law. Not a person who will be listening to information that is not directly related to the hearing issues. Sometimes parents who are pro se want to call a witness from the LEA, perhaps the child's teacher or the speech pathologist or the psychologist who tested their child. If this is the case, first ask the attorney from the LEA if the witness will be there voluntarily. In other words, will the LEA produce the witness you want to call? If the person does not work for the LEA any longer, you can ask the hearing officer to give you a subpoena, which you will then send to the person that you want to appear. Again, the person at ODR can explain to you exactly what information you need to give the hearing officer when requesting a subpoena. It sometimes happens that when parents file a request for due process and do not provide enough information on the complaint form. Remember earlier I talked about how important it is to fill out the form completely, that you need to put the issues, the facts around the issues, and the resolution you seek. In other words, what you want the hearing officer to order on the form. The LEA attorney may send the hearing officer with a copy to the parents what's called a sufficiency challenge. Within 5 days of receiving the sufficiency challenge, the hearing officer must decide whether, in fact, the parent's complaint meets the requirements of the IDEA. If the hearing officer finds that the complaint is not sufficient, the parents will be given an opportunity to amend or revise the complaint and refile it. When an amended complaint is filed, the timelines start over, and the day the amended complaint is filed becomes day 1. Okay, so the hearing day has arrived and you're ready for the hearing. Unless your issue is not complicated, plan on the possibility of 2 full hearing days and perhaps more. Sometimes parents are surprised because they're used to IEP meetings taking 1 or 2 hours. The hearing is very different from an IEP meeting. It is a formal process that can very well take a whole day or more. Always plan for child care at the end of the day because the hearing may not end at 3 p.m. or even at 5 p.m. It's a good idea to bring water and pack a lunch in case you need it. Let the hearing officer know if you have any situation that would require regularly timed breaks or the possible need to answer an urgent phone call or any other factors affecting the flow of the day. At the hearing, there's the hearing officer, the court reporter taking down everything that's said, the attorney for the LEA, yourself, your child if appropriate, your attorney if you have one, the director of special education or another LEA representative, and witnesses for both sides. Parents may also invite friends or observers for support, with the understanding that they cannot participate in the hearing. Only you can choose whether the hearing will be open or closed. In an open hearing, anyone from the public may attend, and the decision with your child's name on it could be released upon request of an interested party. In a closed hearing, only the persons I mentioned just now may be present, and the decision in its original form may only be released to the parties to the hearing and anyone who has to implement the decision. All witnesses are asked to swear or affirm that they will tell the whole truth and nothing but the truth. Parents who are witnesses in their own due process hearings will also be sworn in. Sometimes hearing officers will swear in a pro se parent from the beginning of the hearing. After very brief opening statements from each side will then present witnesses and may include documents called exhibits while presenting witnesses. When the LEA presents witnesses, you or your attorney will have an opportunity to question those witnesses. Also, after you and your witnesses are questioned by you or your attorney, the attorney for the LEA will have an opportunity to question you and your witnesses. Usually, when parents represent themselves, they're permitted to testify in narrative form rather than in a question and answer method. Okay, so the hearing day has arrived and you're ready for the hearing. Unless your issue is not complicated, plan on the possibility of 2 full hearing days and perhaps more. Sometimes parents are surprised because they're used to IEP meetings taking 1 or 2 hours. The hearing is very different from an IEP meeting. It is a formal process that can very well take a whole day or more. Always plan for child care at the end of the day because the hearing may not end at 3 p.m. or even at 5 p.m. It's a good idea to bring water and pack a lunch in case you need it. Let the hearing officer know if you have any situation that would require regularly timed breaks or the possible need to answer an urgent phone call or any other factors affecting the flow of the day. At the hearing, there's the hearing officer, the court reporter taking down everything that's said, the attorney for the LEA, yourself, your child if appropriate, your attorney if you have one, the Director of Special Education or another LEA representative, and witnesses for both sides. Parents may also invite friends or observers for support, with the understanding that they cannot participate in the hearing. Only you can choose whether the hearing will be open or closed. In an open hearing, anyone from the public may attend, and the decision with your child's name on it could be released upon request of an interested party. In a closed hearing, only the persons I mentioned just now may be present, and the decision in its original form may only be released to the parties to the hearing and anyone who has to implement the decision. All witnesses are asked to swear or affirm that they will tell the whole truth and nothing but the truth. Parents who are witnesses in their own due process hearings will also be sworn in. Sometimes hearing officers will swear in a pro se parent from the beginning of the hearing. After very brief opening statements from each side will then present witnesses and may include documents called exhibits while presenting witnesses. When the LEA presents witnesses, you or your attorney will have an opportunity to question those witnesses. Also, after you and your witnesses are questioned by you or your attorney, the attorney for the LEA will have an opportunity to question you and your witnesses. Usually, when parents represent themselves, they're permitted to testify in narrative form rather than in a question and answer method. When you testify, either during questioning by your attorney or by yourself if you're pro se, tell the hearing officer what he or she needs to know and understand about your issue. During the hearing, be respectful of the process. Listen to the hearing officer. Remain centered and calm. Avoid sarcasm. It is not helpful at all and presents a witness in a bad light. Just be frank and honest. Tell the hearing officer about the problem as clearly as you can. I want to say a word about the opposing attorney, the attorney representing the LEA. The attorney for the LEA is doing his or her job, okay? They're going to ask questions of you and your witnesses, and sometimes the questions will seem hard, and sometimes they may seem on the verge of being hostile. They are just doing their job. When I treated children who were sexually abused, I would sometimes prepare them to testify in court, and one of the things I would tell them is, look, the guy that did this to you has a lawyer, and the lawyer's job is to get the judge or the jury not to believe that the guy did it. I would tell them that to make people believe the guy and not believe you, that lawyer will look at you with mean eyes. He will frown at you, but you know what happened, and you just tell the truth how you remember the truth. I would say the same to anybody who's a witness in a due process hearing, whether it's the parent or school personnel. The opposing attorney is doing his or her job, so understand that and just take it as part of the process. You have to remember that a due process hearing is litigation, and litigation means fighting. In a hearing, the fighting is polite and civilized and sometimes even cordial, but it is still fighting to have the hearing officer see it your way in accord with the law. The party that files for the hearing is the side that has the burden of proof. That means you have to prove your case. The standard for proof is which side has the more evidence that is credible. If both sides are equally credible and exactly balanced, then the party asking for the hearing cannot win because they didn't have more evidence than the other side. This equal balance virtually never happens. Maybe in 20 years, 2 or 3 times I said, well, on the one hand, but then on the other hand, it's 50-50, and there's just no way to break the ice. Doesn't happen often. Hearing officers judge the credibility of each witness. That is, does the hearing officer believe the witness, and if so, why, and if no, why not? If you read decisions on the ODR website, you will read the hearing officer's comments about credibility of witnesses. Hearing officers will often find witnesses to be credible about the facts presented, although sometimes there are some memory issues. The hearing officers will understand that memory issues do arise, and that may or may not impact on the credibility of a witness. One mistake that brand new attorneys and pro se parents make frequently when they're asking questions of a witness from the other side is that they try to convince the witness to agree with them. They will elicit a fact, such as the teacher did or did not do something, and then try to pound it home by saying something like, well, you should have done or not done that, right? Several times, trying to get the witness to agree with them. Getting a witness to agree that he or she was wrong is not the purpose of questions. Questions are to bring out the fact that something did or didn't happen, or to clarify things the witness said. You will not be able to convince the witness of a different position, so don't make that mistake. It's the hearing officer whom you have to convince. After all the witnesses have testified, the hearing officer will allow the parties to give brief oral closing summaries of their cases, or to give written closing statements if the parties both decide they wish to do this. Once the hearing officer has heard all the evidence and has looked at all the exhibits and considered the closing statements, then he or she will write a decision that will be issued on or before the decision due date. Decisions tend to be pretty long, 15 or 20 or maybe even 30 or more pages. The hearing officer will send it by email to you or your attorney if you have an attorney, and to the attorney from the opposing side. The hearing officer will also send a copy of what are called the appeals procedures to the parties. A party who is in disagreement with the hearing officer's decision is perfectly welcome to appeal that decision to a court of competent jurisdiction, the federal court or the Commonwealth Court. So, if you get a decision and believe the hearing officer is wrong, you may file for an appeal, and a judge will review the decision and the court reporter's transcript and the exhibits and decide whether the hearing officer was right or wrong about the law. Sometimes hearing officers are told by the judge, we don't agree with you because you made a mistake in the facts juxtaposed with the law. We hearing officers all get used to being reversed on appeal once in a while, although more often than not, the judge will find the hearing officer did correctly decide the case. I have been talking about hearings where parents make the hearing request. There are also times when an LEA files for a hearing. It is important to know that there is a big difference in timelines between hearings that are asked for by parents and hearings asked for by LEAs. When parents ask for hearings, there is that 30-day resolution period before a hearing can be scheduled, and the decision is due in 75 days. But when LEAs make the request, there's no 30-day initial period, so the hearing may be scheduled more quickly and the decision is due in 45 days. The most common occasions on which a hearing officer hears a case on a complaint from an LEA is when a parent has asked for an independent evaluation, what's called an IEE. It may happen that an LEA does an evaluation and produces that evaluation report, and the parents disagree totally or in great part, and they ask the LEA to pay for an independent person to do another evaluation. What the parent is asking for is an evaluation done by an outside expert, but at public expense. Once a parent makes a request for an IEE, the LEA has two choices. The LEA can either say, okay, we will pay for an independent educational evaluation and tell you how you can go about it. Or, we think we've done a fine job, we've covered all the bases to explore your child's needs in order for the IEP team to create a good IEP, so we're not going to give you an independent educational evaluation at public expense. If the choice is to deny the IEE, then the LEA must ask for a hearing. Most times, parents are pretty surprised when in their email they see a request for a due process hearing that they haven't filed for, and in addition to that, a couple days later, getting the hearing notice and information from the hearing officer. It's kind of disconcerting for parents to have that happen, so I prepare you that that might happen if you ask for an independent educational evaluation. In these cases, the LEA has the burden of proof. That is, they must prove to the hearing officer that their evaluation is appropriate under the law, and if not, the hearing officer will order an independent educational evaluation at the LEA's expense. One thing that I do caution parents about is that independent educational evaluations are not second opinions and not granted simply because the parent has lost trust in the LEA. In order to have a hearing officer rule in the parent's favor in an IEE case, the LEA must fail to show that the LEA's evaluation was appropriate, that is, that it had all the elements the IDEA says it must have. The next circumstance under which LEAs will sometimes file for a hearing is to have its proposed program and placement offer ordered by the hearing officer. This is fairly rare, but it does happen when the parties have gone around and around and cannot agree on what is an appropriate program and placement. I will now talk briefly about the kinds of issues about which parents commonly file hearing requests. Often, parents will request a hearing because they believe that their child's program and placement have not been appropriate and will ask for changes, and also ask for compensatory education services, which, if the parent prevails, the hearing officer will order, being very specific about the amount and type of services to be given, sometimes by whom, as well as a time limit by which the services must be used. Parents will also file for hearings about related services, speech services, social skills training, occupational therapy, physical therapy, transportation, one-to-one aids, nursing services. If the hearing officer finds in your favor, he or she will order that those services be put in place, or will order the amount at which already existing related services should be provided. Sometimes hearings are about least restrictive environment, called LRE. LRE is the least restrictive environment appropriate for the child. For some children, all-day full inclusion in general education classes with supplementary aids and services does work. For some children, it does not work. For many children, a combination of special education classes and general education classes works. LRE for the child is what's appropriate for that child at that particular time in that child's education. However, even children in full-time special education classes almost always are with general education peers for example, lunch, recess, sometimes specials such as music and art, sometimes with an aide. Unless a child is in a specialized school, it's very rare that the child is 100% in special education classes. Another type of case that may be assigned to me deals with tuition reimbursement. Sometimes parents decide that a private school would be better for their child but want the LEA to pay for it, so they ask for a hearing to obtain tuition reimbursement from the LEA. Of course, parents have the right to decide where their child goes to school, but, and this is an important but, it doesn't automatically mean that the LEA has to pay for it. Remember what I said before in this talk, and this applies to all types of cases. The standard is appropriate, not best in the world, or everything that a loving parent would want for their child. The standard is appropriate, not ideal. And specifically in looking at a tuition reimbursement case, the hearing officer is not weighing which is better, the LEA's proposal or the parent's proposal, but rather, is what the LEA offered appropriate? That's the first question. If the LEA offers an appropriate program, in other words, a program that adequately meets the needs of the child, then the hearing officer must find in favor of the LEA. However, if the hearing officer finds that the LEA placement was not appropriate, then the hearing officer will consider the private placement to see if it is appropriate for the child. If so, the parents may receive tuition reimbursement. If not, reimbursement is denied. Sometimes parents privately place children in placements that are not appropriate to address the child's specific needs, and if so, the hearing officer will not order the LEA to pay for that program. Finally, if the LEA's program was not appropriate and the parent's program is appropriate, the hearing officer will look at equities. That is there anything that has happened in the course of the relationship between the parties that would lessen or even cancel out the LEA's responsibility to reimburse the tuition? There are two kinds of cases called expedited cases, in which the hearings are handled in a much faster fashion than hearings are ordinarily handled. Hearings about children ages birth to 3 and extended school year, ESY hearings, must be done in 30 days, soup to nuts. That means that the hearing must be held and the decision issued in 30 days or fewer from day 1, which is the filing date. This makes sense since babies get older every day, and ESY has to be decided before the summer begins. A little bit different but still expedited are disciplinary hearings that must be held in 20 school days, not calendar days, from the date of the request, and then the decision must be issued 10 school days after the hearing is concluded. And that concludes this webinar. Remember that the Office for Dispute Resolution is available to provide more information through its consult line, through the Parent Engagement Project Manager, and on its website. I thank you for your time and your attention.